All right, good morning, everyone. From what I see, Claudia is with us and ready. I did want to, just say a few things before we begin. A lot of people have been wondering, how come you're doing this consistently every Tuesday and Thursday, your regular masterminds? And I said that I needed some normality in my life and I wanted to bring some normality to your life, right? So I have been doing masterminds every Tuesday in the Kendall area, for a little while now. And I've been doing masterminds every Thursday in the Doral area for a little while now. So I needed to keep the schedule the same as I've always had it. And I wanted to be as consistent as possible. So, thank you so much for everybody joining in. Claudia, again, I cannot stress enough how amazing it is to have you in our life, right? Not just in mine, but in ours. I met Claudia in one of the chat groups that I've been monitoring for a little while. And, you've just been, so involved with everything, and you've been wonderful, and you answer every question. And the last time I had you on one of the masterminds, everybody was asking about deeds and how deeds work and what it all means. And, here we are doing this deeds class.
Yes, we've been talking about it since the last class. Like Andreina said, there were a lot of questions surrounding deeds, the different types of deeds, the different ways in which you take ownership through a deed. So we finally got the chance to put it together, and here we are today, hopefully to answer any questions that you guys have regarding deeds, and so that when you have these questions come up throughout your real estate transactions, again, this is for an educational purpose, just trying to help you guys better understand the process from a 360-degree perspective. You are not attorneys. You should not be drafting deeds. You should not be giving advice on deeds. But just so that when you see a deed, you have the ability to read it correctly and understand the implications behind it, and what everybody's percentage of interest or whatever the case may be.
Yes, I went through something similar like this with my aunt. I took full responsibility of my aunt who has Alzheimer's, and we thought she was a third owner of an apartment, and what it was a life estate deed, right? So once somebody else passes away, then it becomes hers. So this class is also something that was very important for me to know, so that when I look up a deed, I can understand what's going on.
Correct. So, Andreina, we'll get into it then. We ready to go?
No, we're ready to go. The floor is all yours.
Okay. So basically, there's a few different types of deeds that are used to convey property in Florida. The three most common types of deeds that you will see are, number one, a warranty deed, number two, a special warranty deed, and number three, a quit claim deed. That is spelled Q-U-I-T, not to be mixed up with a quick claim deed, which a lot of people mispronounce. So it is a quit claim deed with a T at the end. And basically, each one of those deeds has different protections behind it. So you would never purchase a property from someone for good value under a quit claim deed, because you basically have no protections whatsoever. The best and most common type of deed that you will see is a warranty deed. That is the deed that usually comes with title insurance. And when you acquire a property through a warranty deed, you have a warranty that there are no issues in title when it comes to that property. If there are issues in title, you can go back to either the person before you, or in this case, your title insurance, because when you acquire property through a warranty deed, there are certain warranties that are made of the title at the time of the transfer. So if you ever see somebody that has a warranty deed, in theory, they are supposed to have clean, great, perfect title to their property, and there should be a promise behind that transfer that the property has no liens, no encumbrances, no other claims by anybody else other than the owner. The other type of deed that you may see commonly when it comes to transfers of real property in Florida are special warranty deeds. A lot of times you'll see these deeds when it comes to REOs or bank-owned properties. When the bank forecloses and then turns around and sells the property, a lot of times that buyer will get what is known as a special warranty deed. This deed is basically a limited warranty deed in that the bank only guarantees that there are no issues on title during the time that they had the property under their name. So they don't necessarily guarantee any issues or defects on title from before the time when they acquired the property. A lot of times when you do a purchase through an REO, they still have to issue title insurance, or they still do issue title insurance. And there's no issue as to whether there could be other defects of title, because in theory, they would be cleared at the time of closing, at the time that you were issued a new title insurance policy. Any defects that appeared on title are taken care of at that time. So when you acquire title, you would obtain clean title. But again, the bank only becomes responsible or takes care of the issues that appear during the time that they held title themselves. And then the last type of deed that's common in Florida for these transfers of real property is what you all know as a quitclaim deed. This is basically most of the time used when it's a transfer between family members or friends, or if it's a transfer for minimal value or less than what would be considered market value. And the reason why this is the deed that is used is because it contains no protections. In law school, when we study this, we are basically told that this is the buyer beware deed, because you have to beware of any issues that come up, because you would be subject to any of them. All it takes to do a quitclaim deed is to basically, a lot of times, notaries do these deeds, and I don't recommend that you ever get a notary to prepare a quitclaim deed for you. And at the end of the class, you'll understand why. There are very small changes that could affect ownership via quitclaim deed that a notary maybe will not know the difference, and then you may not end up with what you think you had in interest at, within a property. But a lot of times this is the deed that you see notaries sometimes prepare. And it's just basically a transfer, usually between, like I said, family members or friends, or transfers for minimal value, where there are no protections, there's no guarantees, there's no promises. The only promise is you are now on title. That's it. But if anything happens with the property, if anything comes back later, if there's, some sort of issue with a lien or a code violation or whatever the case may be, if you have a quitclaim deed, you're basically responsible for anything that would come up. And so for that reason, that is the least preferred way to transfer property in Florida. But sometimes it's the best mechanism, depending on, what the goal would be and what the specific intent of the parties is at the time of contracting or of transferring the property. Those are basically the three types of deeds. Within the types of deeds, there's different language that is included when it comes to ownership, right? So whether you have more than one person on title, or if you have one person on title with a remainder, there will be different language in each deed to satisfy or accomplish the goals of the parties in their transfer. Before I move on to the different types of languages in the deed, let me just go back. I usually say this at the beginning and I forgot today. At the bottom of your screen, you're gonna see that there's a chat button available. Click that button, and on the right-hand side, a little chat panel will come up. You can type in messages to everyone in the chat in that panel. Feel free to go in there, type in whatever questions you have as I'm explaining either the different types of deeds or the different types of vestings within a deed, so that if there's anything that I wasn't clear on or that you want me to explain a little bit further, just feel free to go in there and leave me a message, and I will do my best to try to clarify or answer all of your questions. Beth, yes, Andreina records all of these trainings, and she is very gracious to put them on her website for everyone to be able to access it later on if they want to refer back to it, or if they weren't able to attend during the actual live taping of the training itself.
Yeah, correct. Everything's being recorded and everything will be on the website within an hour or two of the class happening.
So then if we don't have any questions so far on those three different types of deeds and the, different, Marina is asking which were the other two deeds apart from the quitclaim deed. Marina, the quitclaim deed, QUIT is the correct name. Is the last deed that we discussed. The other two types are the warranty deed and the special warranty deed. Those three types of deeds are the three that you will see almost in every single transaction. There are small variations that you may see. Other than that, you may see what are known as a trustee's deed or a personal representative's deed. Those are basically going to be one of the other types of deeds. They're just titled differently because they need to basically give notice that it's a special type of deed, such as the trustee's deed or personal representative. The trustee's deed is usually when there is a trustee of a trust that gets the authorization to make decisions regarding that property on behalf of the trust. And the personal representative's deed is usually a deed that is given to the personal representative of the estate in a probate action to give them the ability to also take control of the property, sell, refinance, do whatever on behalf of the estate. So those are the three types of deed: the warranty deed, the special warranty deed, and the quit, Q-U-I-T, claim deed. So then we'll go into the different languages, the different types of vestings within a deed, right? So whenever you have a closing, a lot of times you will see that your buyer specifically is asked, if they're married, or who will be taking title along with them if it is not a finance transaction. So when you only have one person on the deed, it's pretty obvious. There's one person on title. They get to do whatever they want with the property. They are the sole owner of the property, and they can make all decisions on behalf of the property. When you have husband and wife on title, you will see that there is a specific notation on the deed that says as husband and wife, because they have a special type of interest in that property, which gives them the right of survivorship. The right of survivorship, meaning husband and wife are on title. Unfortunately, something happens to either husband or wife, the other person automatically retains the full right to that property without having to take any additional steps other than possibly recording a death certificate to cause the title or the deed to automatically transfer for all the interest to the surviving spouse. So whenever you have husband and wife on title, you have a special protection, let's call it, where husband and wife are both on title as long as they're both alive. And in the event that something were to happen to one or the other, automatically the property would transfer to the surviving spouse. Sometimes all you have to do is record a death certificate, and then the surviving spouse will be the only person on title. They'll have the right to do whatever they want with the property. The next most common thing is when you have different people on title. When you have different people on title, the most common way that you will see them is as joint tenants. You see them as tenants in common. Tenants in common meaning if I and my sister, for example, are on title, my sister and I each have a 50% interest in this property. If something were to happen to me, even recording my death certificate would not cause my 50% to automatically transfer to my sister so that she becomes the sole owner of the property. Instead, if I have a property with someone and we are tenants in common, if something happens to me, my percentage, now I'm giving you 50% in this example because there are two people, but you can have 5 people, 7 people, 10 people, and all have a percentage. It doesn't even have to be equal percentages. You can even distinguish what percentage each person has, regardless of whether one person has more or less. You can divide it however you want. So if there's 2 people on title, we are tenants in common, I pass away, my 50% automatically goes to probate. Unless I have some sort of setup or I did the proper estate planning so that in the event that 50% I pass away and it becomes, it transfers on to my heirs or to whoever it is that I established through my estate planning documents. My sister, who remains on title, will only have a say for 50% of the property. And obviously, if I'm not there anymore, she will not be able to do anything with that property without my heirs or whoever else it is that comes after me to take over my 50%. I have actually had people in Andreina's chat reach out to me about this precise situation where there was a family, there were brother and sisters that were on title. I believe there was 4 of them, if I remember correctly. One of them passes away. They go through a probate action to be able to administer that percentage. That percentage ends up being split up between the brothers and sisters so that the 3 people on title all gains a little bit more interest in the property. Those 3 people were on title. They were ready to list the property for sale. And unfortunately, one of those people passed away again. And again, they had to go through the entire probate process. It's not that tenancy in common is unfavored, disliked, or anything like that. It's just that you have to make sure that if you have an interest in a property as a tenant in common, that you know, or that you have the proper documentation in place to not leave the other people on title hanging in the event that something does happen to you. Because like I explained, what happens is that you leave the people with you on title in a situation where they have to go through probate to be able to take action with the property if you're not around. So it's very important to have a conversation if you or your clients have someone that they are on title with as tenants in common, that you have a conversation with them, or that they have a conversation with the other people on title to explain that we need to make sure that the proper vehicles are in place through an estate plan, so that in the event that something happens to one of the people on title, the rest of the people can continue with the property, whether it be that somebody steps in to take their percentage, or that percentage then gets passed on to the other person on title. But just so that in general, you don't leave the other people on title with a hot potato in that moment until they can, go through probate or get that problem resolved. One of the ways to know that people on title are tenants in common is that the names are just listed. It's not going to say as tenants in common. It's just not going to say anything. There are many different ways to effectively and correctly write a deed. There are also many ways to incorrectly and ineffectively write a deed, but there is not one size fits all language. There is certain language that needs to be in there. Like I said previously, as to the husband and wife, you need to have marital statuses on deeds, because there are certain situations where if someone is married and they're selling a property, even if their spouse is not on title, their spouse does need to sign. So one thing that all deeds have to have is marital statuses. And then usually if a deed does not say as joint tenants with right of survivorship or as joint tenants, then you can assume that it's because they are tenants in common. But again, that depends on the entire deed, the rest of the language in the deed, and what it says. Another type of deed that we have spoken about recently, which is I think the reason why this all came up, is there is a type of deed in Florida, or that's used in Florida, that is called a ladybird deed. That's the common name. And then it's also known as an enhanced life estate. That is the actual formal legal name of it. The enhanced life estate is basically a deed where the people who appear on title, the people that you see their names normally, have the ability to do whatever they want with the property as long as they live. So they can sell it, they can paint it, they can mortgage it, they can refinance it, they can rent it, they can do whatever they want with the property. But the deed will say, to me, Claudia, for life. Remainder, which is why it's called an enhanced life estate or a ladybird deed, after my life is over, the remainder, meaning anything left after my life, goes to XYZ. You can put a child, you can put a sibling, you can put a parent, you can put a spouse, you can put anybody that you want on there. So that what happens is that effectively, through doing that, as long as the person who's receiving the property is alive at the time that you pass away, you avoid probate. And so then what happens is the language on the deed would read, to Claudia, a single woman, for life, remainder to her sister, a single woman. So what would happen is that as long as when I am no longer around, the day I die, again, with recording a death certificate, that interest would automatically pass to my sister, assuming, of course, that my sister is actually alive at the time that I pass. And by doing that, you basically avoid one of the major assets that are the reason why people end up in probate. Because there are ways to avoid probate by doing beneficiaries on a lot of your accounts. You can put beneficiaries on your bank accounts, on your 401k statements, on your life insurance policy. A lot of those things automatically transfer at death if you have the beneficiaries in place and you set them up correctly. However, property does not automatically transfer upon death unless you have something like a ladybird deed or an estate plan in order to be able to make that happen. So something that I recommend to almost every single person that does a closing in my office, as long as the lender permits it. I have never had a lender tell me that they had an objection to a ladybird deed, but I always check. They are the ones that basically tell me what I can and can't do when it comes to the deed. Whenever I have a lender that, I haven't worked with before, I double check. If I get a green light, I offer it to the client. This is the ability of doing a ladybird deed. These are the benefits of doing it. If you are interested, now that you're already doing a deed, you're already paying doc stamps, you're already doing the transfer of the property, let's go ahead and put something in place so that in the event that you're no longer here tomorrow, the day after, whatever the case may be, then somebody else will be able to take over the property quickly, efficiently during, a difficult time if you were to pass away. Again, if there are two people on title and there's spouses, for example, husband and wife are on title, one of the two passes away and they have a ladybird deed, it doesn't automatically go to the person on the remainder. It will again transfer, like we spoke earlier, directly to the other spouse. The other spouse then becomes the only actual owner of the property for their lifetime. And from then, they can then change the deed, refinance, sell, mortgage, whatever they want, until they are no longer around. And if they have not changed the deed while they are alive, then that remainder man would then get to have possession or title on that property. Nancy asked on the ladybird, if you leave to a child and they are married, does it become both of their property? Yes and no. That is a very difficult question to answer, Nancy. The reason being, the only person on title will be the person that you leave. So if you left your child is going to get the property and have title of the property. That property can be deemed an inheritance. That would be my argument. So technically, the only person on title will be child. However, there's different ways in which you can cause that asset, being the property, to become a marital asset. For example, if you remodel the property, if child remodels the property, there is an argument that that becomes marital property because the assets of the marriage are used to remodel the property. Or if, for example, there's certain maintenance that needs to be made to the property, and that property, then you put $10,000 into a new AC. Again, that is something that could be argued that it becomes a marital asset to the extent that you put money into it. It's called commingling. That property basically would have to stay by itself without any marital funds being used toward it. But technically, I would argue that that's an inheritance that could not be touched. However, if they refinance, there's other things that could be done later on that could cause that to become a marital asset. So you have to be very careful. But yes, if you leave it to your child and your child basically doesn't commingle any funds or doesn't use any marital funds to go ahead and make repairs or whatever the case may be, then the argument would be that that is a non-marital asset that was inherited. Another reason why it's so important to be aware of the deed on a property and what it says. So Florida allows for something called a partition action. I don't know if any of you have ever had a situation where you've had a property in partition, whether it be on behalf of your clients, or a lot of times this would lead to a listing for you. And basically it's when you have more than one person on title and or at least one of the people on title want to, for example, sell the property and the other person does not. Or they just can't come to an agreement as to whether they want to remodel the property or they want to rent out the property or whatever they want to do. There's just a breakdown, let's say, in communication, or they're just not on the same page anymore as to what they want with that property. What happens is Florida has a statute that allows one of the parties on title to file what is called a partition action to force either the sale, the refinance, the buyout of their interest in that property so that they can basically remove themselves from the situation. For example, a lot of times this happens when parents leave property to brothers and sisters. Brothers and sisters are on title for a while, there's no issues, whatever, they're renting the property. And then one day, one brother or sister wants to sell, the other one wants to keep renting, they can't get along. The first course of action, obviously, is to always have a conversation between those people, right? Hey, look, I think this is the best course of action. This would be the best thing to do. I think whatever, this would be the most efficient way to handle the situation. But sometimes brother and sister cannot get along, cannot come to the same conclusion. They're not on the same page. And so then that allows one of the parties on title, whether it be brother or sister, to go to the court and file a partition action where the court will basically determine that one of the two has to buy the other out, usually done through a refinance of the property where you cash out and pay the other side, or the other party has the right to list the property for sale and get their portion out of the sale of the property. Each side will get their percentage, and then from there they move on, either buying another property, putting the money in the bank, whatever it is that they want. So it's very important that you know what your rights are on title, on a deed, so that you know what your rights are in the event of a conflict like this. A lot of times those actions for partition, the statute does permit for attorney's fees and costs for the prevailing party. I would venture to say that there are almost no defenses to a partition action, because you always have the right to alienate that property, to not be stuck or tied to that property. So it's almost, I don't want to say it's 100% slam dunk. It's not 100% slam dunk, but once you file a partition action, you pretty much know that something's going to happen. They're either going to refinance, they're going to come to some sort of agreement to buy you out. Something will definitely take place with that property, because when you file a partition action, basically one of the two parties has just had it, they just don't want anything to do with that property anymore. And the court will force some sort of action to happen so that that party isn't stuck in that situation that they formally decided that they do not want to be a part of anymore. DG said, would an operating agreement including a buy-sell provision help avoid the partition action? That is a good question. However, it depends on the language. I would argue that unless it specifically does not allow a partition, that you could still do a partition. In this case, what I'm understanding from your question, and please clarify if I didn't completely understand, is that if it's an operating agreement, it means that an LLC owns the property. So there's technically only one person on title. So in that event, you would not be able to do a partition because there's nothing to separate. There is nothing to break up. There are not two people against each other to file the partition action. If you have an operating agreement, it means that there is one entity on title, and then it's a matter of whether the owners of that entity have to agree or not to buy or sell their interest in the LLC or the corporation, whatever the entity would be. However, a lot of, for example, my operating agreements, one of the areas of law that I practice is business law. And a lot of my operating agreements have sort of like a right of first refusal built into the operating agreement, so that if at any point a shareholder or a member wants to get out of the LLC, my remaining clients would have the opportunity to buy them out before they go to a random that they find somewhere to buy their interest. So in that sense, you would not necessarily be able to avoid a partition action, because if there is only one entity on title, I do not believe that you will be able to do a partition action. However, there are different ways within the operating agreement to treat a situation where there is a member, an owner, or a shareholder who no longer wants to be a part of that situation to remove themselves. And I think that usually the best way is to have a right of first refusal, because that way you give the current owner, shareholders, members the opportunity to be the first ones to purchase or buy out that other interest that becomes available before they go find a complete stranger or somebody else in the industry to purchase their industry on that behalf. So that's basically one of the reasons why it's very important to sorry, I'm reading DG's message. Great point. I'm wondering what you advise for investors to have in place prior to partnering in a property. That is a great question. And that is like a whole conversation within itself. I advise all of my clients to get a formally drafted operating agreement by an attorney before they actually start doing business under an LLC. The reason that I do that is because a lot of times when everybody's putting their brains together and putting their money together to do this great idea that they have, everything is rainbows and butterflies. But unfortunately, sometimes when you run into hurdles, which you will at some point throughout your project or your venture, whatever the case may be, it's like a relationship that you're in, and there's going to be good days and there's going to be bad days. And sometimes people do not deal with that stress or that adversity in the best way, or they're not as reasonable under those circumstances or under that pressure. And so then basically what you do when you have an operating agreement that is well and fully drafted by an attorney is you come up with all these scenarios of different things that could happen throughout this partnership or this relationship that you're starting. And on a good day with cool heads, everybody gets together and decides this is the way we're going to treat these circumstances if they arise. And then in the future, when you don't have the good days and there aren't cool heads, you don't have a lot of wiggle room to be able to let emotions and stress and pressure get in the way of those situations, so that you're able to basically refer back to your handbook, is what I call it, and you go find out what you agreed to do in that circumstance back then. And it's almost like a roadmap to how you will run that LLC, the corporation, whatever the case may be. So I definitely do think that is a huge priority for anyone that's starting an LLC or a corporation, to have the proper foundation documents in place. I know everyone can go to Sunbiz. I know everyone can fill out the form and start the LLC or the corporation. The issue is that by doing that, you leave a lot of gray area as to what it is that will be done in the future in regards to specifically real estate. This specifically applies to investors. Again, I think it's important for anybody in any kind of venture, but again, tying it back to the real estate, the investors or the flippers are the ones that I specifically recommend this to, specifically because, like you said, there's not necessarily a way to do a partition action if we all own an LLC and an LLC is on title. So very important to have that conversation early on. I say that it's similar to a prenup. You basically are planning the bad days while you're still having good days. And I promise you the bad days are going to come. It's just a matter of how everyone handles it. And, you know, being able to have something to look back at that you agreed upon in the past is always going to be helpful in a situation like that, because there's no room for hot heads. There's no room for stress. And, you know, it's just, this is what we agreed upon doing. Let's do it. And it also can provide an out, like I said, when you don't have the opportunity to do a partition action like that when it comes to real property. You guys, I encourage you to keep asking questions if you have any. This is a super broad topic. There's a lot of different angles and a lot of different ways that we can go with it. In general, the point is that it's very important to know, right, what kind of deed you're getting, what kind of protections you have behind that deed. And then again, what it is that each person that's on title has a right to, or doesn't have a right to. So I'll tell you about another very popular scenario that I've been coming across lately, specifically now with the COVID-19. COVID-19 is causing a lot of daily changes in the mortgage industry. I know that last night someone circulated an article in Andreina's chat that Chase now requires 20% down payment and a 700 credit score for a mortgage. It's great if you can still meet that, if you have 20% and you have a 700 credit score, but the reality is that not everybody has a 20% down or a 700 credit score, and they still want to be able to not rent. They still want to have the possibility of owning a property. And so then what ends up happening is that they have to go to lenders, which I think is great for the industry, because now all these mortgage brokers are getting more clients based off the fact that these bigger banks are not giving the products that can meet the population's needs right this moment. But a lot of times in recent days where there have been many changes that the credit scores have been bumped up or the guidelines have been changed, what I've seen happen in some of my contracts is that my contracts have brought in another buyer. And then obviously bringing in another buyer, what they're doing is using somebody else's credit or somebody else's file to make their file then be able to meet certain guidelines that they could not meet on their own. This is something that happens in the industry often. It doesn't necessarily only happen now because of what's going on. Sometimes people just simply don't report the proper income on their taxes, or just don't have the proper credit score to be able to purchase a property. And so they have to bring in a family member or someone to be, you know, their co-signer on the mortgage, but really it's just, they're both on the mortgage, they're both on title. And so then I usually advise those clients that they need additional documentation other than just your deed and your closing documents, you know, specifically when there's a party that you're adding to this transaction for the purpose of financing. If you're adding them to the transaction just to help be able to obtain financing, by default, that lender will require that that person is on title. So you're giving that person basically 50% of the interest in your property. Specifically, when that person is literally only on there because you need them to get approved for lending, then you have to understand that they're not putting in down payment. They're not actually making the monthly payments. They're on the hook. If you don't make them, they're going to have to make them, because if not, their credit's going to get messed up. They're also going to get a foreclosure or loan mod or short sale, whatever, on their credit. So they obviously have an interest in making sure that all that money is paid. But in reality, what ends up happening is that they're on there just to help you. You're the one paying closing costs. You're the one putting the down payment. You're the one making the monthly payments, paying the rent. Paying the insurance, paying the taxes, making sure the property is maintained. And when you go to sell, what happens? They're on title. They're on title. At some point, they can go back, or they could file a partition action and say, I own 50% of this property. If something were to happen to you, depending on, again, how the deed was written, they could end up with the property. So what my office recommends is, if you're in that situation, you need to speak to someone, a real estate attorney, not a title company, that can draft a separate agreement that can basically flush out those details at the time of closing, right? So that if there is a partition action that's filed in the future, or if something happens in the future, there is an agreement in writing that they disclaim their interest in that property in the event of XYZ. So obviously the possibilities are endless. It's a whole different class to sit here and tell you guys all of the ways in which that can go wrong. But long story short, it's a way of protecting the person who actually put the down payment, who actually puts in the closing costs, who actually makes the monthly payments, so that one day that other person doesn't turn around and say, I am entitled to 50% of this property. Remember, anyone can do anything. All you have to do to be able to get to court is have the $500 filing fee. That's it. That doesn't mean you have a valid claim. That doesn't mean that you will win the lawsuit. All it means is you can file a lawsuit, period. Whether it's a baseless lawsuit, whether it's a good lawsuit, a bad lawsuit, they're gonna win, they're gonna lose. We don't know any of that. The point is, anybody, any day can file anything as long as they have $500. So what are you looking to do with one of the biggest investments in your life? If you need somebody, a family member, a friend, a cousin, a brother, a sister, to get on title with you, make sure that you have the proper documentation in place, so that if one day something happens, you have that big investment protected. You have to think that it's not just, a lot of people don't like to think this, but relationships do sour. At some point, people have, breakdowns in their relationships. They don't get along with each other anymore. Things happen in life, and you can't just assume that for 30 years, it's all going to be rainbows and butterflies with this person who is entitled to your property. For the same reason, you can't believe that if, God forbid, something were to happen to that person and you're not joint tenants with right of survivorship, you're tenants in common, that their children or their heirs will not come after you for that 50% of the property that you think that they don't own, that they don't have a right to, but they can still come after it. So by having this document, you're not necessarily going to prevent the heirs from filing something, or even the family member who is entitled to, you can't prevent them from filing something, because unfortunately that's due process. The Constitution allows them to do that, to go in and file the lawsuit. But you have a document that will basically say, this is frivolous, or this is baseless, or they're not entitled to 50%, they're entitled to 5%, or they're not entitled to 50%, they're entitled to $5,000, something of that nature, so that you can basically limit their interest in the property, despite whatever the deed may say, where they actually acknowledge in writing before a notary with all the formalities that they don't actually have an interest in that property. So that in the future, the next 30 years, if you own your property all the way to the day that you pay off the mortgage, you are protected. And even after that, because when you pay off the property, it's even more appealing. You have a free and clear property that they can claim 50% of. So that's something that I always advise our clients to do if they are doing, putting in a family member or a friend on the mortgage, which automatically means they have to put them on title, to make sure that in the future they don't have any situation like that. Margarita Avila is asking, tenants in common with right of survivorship requires probate. So you can either be tenants in common or have the right of survivorship. You cannot be both. You're either joint tenants with right of survivorship, or you are tenants in common. Tenants in common is the one where everyone has a percentage and that percentage stays with them or their heirs no matter what. Right of survivorship is the one where I said if one person passes, the other person stays. So it's either going to be joint tenants with right of survivorship or tenants in common. Tenants in common does not avoid probate unless you have specific estate planning in place that will help you do that. Joint tenants with right of survivorship avoids probate to the extent that the property automatically passes to the other person on title as the only owner. In this case, if there's two people on title, then one person passes away, they're joint tenants with right of survivorship, then the only person that's remaining on title becomes the only owner of the property. So that would be a way to avoid probate as to the first person that passes. However, if this last person that remains on title now, because the second person passed, they were joint tenants with right of survivorship, and this last person is now the only owner, if this person passes away without any estate plan, without any ladybird deed language to pass along the property, without anything of that nature, then unfortunately, they're still going to require probate to be able to have the family members, the heirs, whoever it is, acquire that property upon their death. But it does temporarily avoid probate between the owners themselves. So Margarita, I hope that answered your question. If anybody else has any other questions, go ahead and type them in the chat. We have about 15 minutes left to go. How complicated is it to change a deed from tenants in common to joint tenants? It's not complicated, but basically there's a couple things that you have to take into consideration, which is, now I'll tie it back in why I don't recommend using a notary. If you go to a notary, not to knock notaries, there are very good notaries out there, but there are also not very good notaries out there who don't know the implications of the paperwork that they do. You can go to a notary and ask them to do a quick claim deed for you. They will do it for you, but they don't necessarily ask you the questions to know what issues you can run into. They just make the deed that you tell them to make, right? They're not giving you any legal advice. So number one, if you have a mortgage on your property, you 99.9% of the time agree to a clause within all your closing documents that says that you will not touch or change the deed to the property in any way. And that if you do, and they find out, they can accelerate your mortgage and ask you for the entire thing like tomorrow, the day that they find out. That's obviously a situation that nobody wants to be in. And that's obviously not a situation that is worth, or changing title is not a situation that is worth you having to accelerate your mortgage. There's a million factors to take into consideration. You may not be able to get a new mortgage. Your income could have decreased, Your credit score could be bad, whatever the case may be. At the end of the day, the first thing that you have to take into consideration is, what is limiting me, AKA a mortgage? Is there a mortgage limiting me? If there is a mortgage, it's important to make sure that the lender or the mortgage permits the change in title. Normally, when it's a change like this, that it's basically the same people on title, you're just changing their relationship, it's not an issue. But I do not ever advise assuming that. You always should double check, make sure that it's not an issue, get it in writing if you can, that they confirm that it's not a problem for you to do it. Don't get me wrong, there's people out there who will do it without calling, without checking, without doing anything. I'm not one of those people. I don't want that on my conscience, that one of my clients ends up having to accelerate their mortgage or that accelerates their mortgage because I did a deed for them by being careless. So make sure that you don't have any limitations with your lender. If there is a limitation with the lender, then there are other ways to do that have nothing to do with changing title, which then that would take you into estate planning. That's what I would recommend in that case, to make sure that when something does happen, it's taken care of, possibly even avoiding probate altogether with a proper estate plan in place. Other than that, it's just a change in language in the deed. So it's recording a new deed. The other thing to consider is that sometimes certain changes in deeds can eliminate your title insurance coverage. So you have to be careful when you're making a change on title insurance, Oh, look, Margarita just actually brought that up. There are certain changes that cause your title insurance to stop being in effect. And so obviously that's another consideration to take place. You know, is the value of you changing title worth more than losing your title insurance? I would say that 99% of the time it's not. So that's a whole different conversation to have, but most of the time it's not worth it because there could be big issues that come up on title that you would basically have to pay out of pocket to resolve if you get rid of your title insurance. But title insurance doesn't become null in every single situation. So again, you would have to speak to someone who can help you analyze that situation and determine what the best route would be, whether it be changing the deed, whether the lender's okay with it, or whatever it is that that can be done to accomplish the goal. There's a lot of questions that came in. Andres, the term ladybird, I asked this to somebody recently and it was because I want to say Ladybird Johnson was President Johnson's wife's nickname and that's where it came from. I actually recently asked that, but if it wasn't Ladybird Johnson, it was another president's wife that had that nickname and that's where the term ladybird came from. Good morning, Claudia. Margarita, we already discussed about the deed making the title insurance null. There are certain situations in which that can happen. Claudia asked, even if we are joint tenants that want to add ladybird language, do we have to talk to the lender? No, that's different because like I explained earlier, you're technically not changing title. If the two people who are on title remain on title and all you are doing is adding the remainder, then you should not have an issue. However, again, I don't like to assume. I like to reach out to the lender. I like to get confirmation in writing that it's not an issue. I could even send them a proposed deed for them to approve if they want to go that far. And in that case, then, you know, you can guarantee that you're not going to have any issues after you record the deed as far as adding someone, a child or whoever, as a ladybird or as a remainder on a ladybird deed. Ileana said, with a ladybird deed that has a mortgage, what will happen after the owner died? So I've seen them where nothing has happened because the person who acquired the remainder, for example, a child, has continued to make the mortgage payments and the mortgage basically hasn't bothered. But technically the mortgage is in someone else's name and title technically has changed. So I believe that legally the mortgage would have a right to accelerate the mortgage at that point. But I mean, worst case scenario, in my opinion, it's better for the mortgage to accelerate and you be able to list that property tomorrow instead of having to go through probate. I don't know how long it's going to take. I don't know how much it's going to cost me. And I don't know when I'm going to be able to list this property. So, you know, it's kind of like the lesser of two evils when it comes to that. But I have seen circumstances where the new owner or the son, the remainder, whoever it is, has taken over, has continued to make the mortgage payments and has not had any issue maintaining that same mortgage on the property. However, legally, title has changed, and I'm sure that they could accelerate the mortgage if they wanted to. Ladybird, a will from Georgia is legal in Florida. A will from Georgia is legal in Georgia. It can be used in Florida to probate any Florida assets. However, it will have to be treated under Florida law. I would recommend that if anyone has a will from a different state, that they have left the state, that they do not intend to make that state their permanent residence anymore, that they obtain a new will in the state that they do intend to make their permanent residence. Specifically in Florida, we have homestead laws that are very, very, very helpful. They help you transfer property without paying taxes, without any sort of penalty to your family members, specifically if you have heirs that are your family. So sometimes it's even more beneficial to do your new estate plan under the Florida laws, depending on what state you're coming from or what state you had your prior estate plan in. But that's a very touchy subject because at the end of the day, you need to make sure that all your transfers and all your devices are in line, correct, and that they don't fail, because once they fail, then they just get transferred by statute. So if there is someone that has a will from a different state that has decided to leave that state permanently and move to a new state, being Florida, for example, whatever state it is, I would recommend that they get an attorney that does estate planning in that new state that they do intend to make their permanent residence, to look over that will and confirm or deny, or whatever the case may be, that that will is still okay or that it works. My office in particular does estate planning, but we do not make changes to wills from other states. Unfortunately, the liability is huge. It can change, or if the law in Georgia changes after I told you that your will was fine or that it was whatever the case may be. I obviously keep up with Florida law, but I don't keep up with Georgia law. And so 99% of the time, I would say that your estate planning attorneys would recommend that you get a new estate plan altogether in the state that you currently reside. I urge you to reach out to someone and see what it is that they recommend based off your situation and your circumstances. But if you have a will in any state and you have property in a state outside of the state where you have a will, so for example, if you have a will in Georgia and you have property in Florida, you will need an in rem action in Florida to probate that one asset, or to sometimes people know it as domesticating the order from from Georgia in Florida to allow the sale of the property or whatever the case may be. So that doesn't mean that you will not be needing an attorney in Georgia for a probate action or anything like that. It just means that you need to make sure that your estate plan is done correctly according to the laws of the state that you reside or that you plan to reside in the near future. And every time you move, you should have somebody take a look at it. Obviously not for temporary moves. Specifically with military families, they choose a state that is their home state for the purposes of estate planning, divorces, things like that, that no matter where in the country they live, that state is still their home state for that purpose, and that they are, everything for them is revised under that state's laws. But if you are looking to make a permanent move, definitely it is important to make sure that your affairs are in order under the laws of the new state that you reside. I hope that answered everybody's questions. We have just about 5 minutes. We have time for maybe one more. Let me know if anybody else has any additional questions. If anyone here in this talk today is not in Andreina's Real Estate Talk WhatsApps, that's a great resource that we've been using. That's how she and I met. There are lenders, inspectors, realtors, I think that's pretty much it. Well, attorneys. But
it's funny because I started the chat with the intent of being like that one-stop shop, right? And I didn't expect it to become what it's been. I think it's like way above of what what my train of thought was when it came to the chat. So yeah, it's been more than a one-stop shop. I think that everybody kind of has become friends, and we do have vendors there, and you've been wonderful on the chat and on every presentation that we've scheduled.
Thank you. But yeah, Andreina, if you want to share the link, if possible, or how they can reach you. Andreina, your Instagram handle is at Andreina_Mon, correct?
Yes, correct.
Okay, and mine is at Claudia C_ESQ. But definitely reach out to Andreina if you're one of my guests in the chat today, because I think that WhatsApp is a great resource for everyone. We ask questions. There is no stupid question. We just help each other. And sometimes you have a new situation that you've never faced before that somebody has experience facing, and everyone is super helpful, and they help you out, and they let you know different ways that they handled it. Again, not giving anybody legal advice or anything like that, but just letting you know this is how I handled it, figure out what the best way to handle it would be, but this was my experience. So I encourage you guys to take a look. Andreina actually just posted it in the chat for anybody who is not already a member to go ahead and request.
And we don't allow solicitation or recruiting on there. It is literally a very clean, just real estate related chat group. There are a few brokers in there. There's a few people in there within our industry that will chime in and speak to everybody, but I don't allow outside real estate talk and no soliciting or recruiting. So I think that it's a safe space for all of us.
Correct.
All right, guys, with that said, let's go ahead and finish it up. And, again, Claudia, thank you so much. I appreciate everything that you have always, done for me, the group chat and every presentation we've put in together. It's been amazing. And,
Thank you.
For anybody who wants to know about when another mastermind events, everything, they are on my website. I have a full list of all the events happening this week. I mean, this week is hot. I
Yes.
will say that. And, if you want to go back and re-see this presentation or share with somebody else, it will also be on the website within the next 2 hours. All right,
All right.
guys.
Thanks for joining. See you guys again.
Thank you. Bye.
Bye.